Hello and welcome to ISV Partner Day Digital 2020. This is a session delivered by Ben Travers at Stephens Scown, and I will pass you over.
Hi, thanks, Alana. As I said, my name is Ben Travers, and I head up the intellectual property, IT, and privacy law team at Stephens Scown. We're one of the largest teams in the UK specialising in that area of work, and we're seeing a huge intake in the adoption of digital solutions as businesses get used to a new way of working in light of the lockdown. On the back of that, not quite the normal talk that we'd be giving at this event, we've been asked to look at some of the trends that we're seeing at the moment as businesses get used to this new way of working. The first thing that I would say is that we are seeing an uptake of digital solutions and technology generally, which far surpasses anything that we would normally see. Industries which traditionally have been quite reluctant or reticent to adopt to digital technologies because of perceived barriers have put those barriers to one side and jumped in with both feet. We spoke recently with a business, for example, who said that they had been discussing internally the options for trading online for about 4 years until this current pandemic happened, and all of those discussions went out of the window, and they went from having no online presence to speak of to having a working online sales platform in about 4 days. So people are making some really quick decisions and doing away with perhaps old reluctances. And whilst that's great for technology companies, it is creating some issues both for technology companies and those adopting the technologies. So the first thing that I wanted to say, the first tip really through this session, is that businesses, whether they are providers of technology or users of technology, should, before they jump in with both feet, stop, take a step back, deep breath, and think about the long-term consequences of the decisions that they're making. And that's a trend that we'll see as we go through the talk today. A lot of short-term decisions are being made very quickly for very good and obvious reasons, businesses trying to survive and thrive, but those short-term decisions will have long-term consequences. As a technology lawyer, a lot of those long-term consequences are relatively easily avoided with just a little bit of knowledge, and hopefully imparting some of that knowledge is what this session is about. So let's move on from tip one. Tip one was take a breath, take a step back, and think about the long-term consequences. So the second tip is to sweat the small print. Businesses, whether they are providing technology or adopting technology, are increasingly using online solutions, whether it's for sessions such as this webinar, or it's to communicate remotely through video with clients and with colleagues. Platforms such as Zoom and Teams are seeing huge spikes in their usage. Not to pick on those platforms, but to talk about platforms generally, businesses should always have a look at the small print when they're uploading content. If you're a developer, for example, and you're taking code from a platform like GitHub, check the small print. That has an impact not only for open source issues, but more generally. People who upload content onto those platforms are entitled to set the terms on which that content is available. And just because it's available for free, i.e. there's no monetary cost, doesn't mean that there's necessarily no commercial restrictions. It's not uncommon for businesses who are taking content from online platforms to take that content without checking the small print and to find themselves using that content in a way which infringes the intellectual property rights of the person that uploaded it. Conversely, lots of businesses are looking at ways in which they can upload their technology to platforms to distribute it more widely. Looking at somebody outside the tech space, imagine, for example, a personal trainer business who's spent many years building up their routines, and they make money out of selling those programs, those routines. In the current environment, they might be inclined to upload those to an online platform to enable their business to continue as they look for digital delivery methods. When they do, though, the terms and conditions of the platforms that they upload to are going to apply. And it's not uncommon for those terms and conditions to have quite sticky terms and conditions when it comes to intellectual property. So if you are uploading content, if you're providing services and it's content that you see a value in, that you've created and that you tend to monetize, be careful about the short-term decisions you make now as to which platforms you upload it to. Check the small print of those platforms. If those platforms have provisions which restrict your ability to use or license intellectual property in the future, then you may find that when you come out the other side of this situation, you can no longer revert to business as usual methods with that intellectual property. Which leads to the third tip. If you are uploading content, consider using what we call trapped data. Trapped data might be, for example, a simple mistake in the data which has no impact on the real meaning of the data, but which is easily spotted by somebody who knows what to look for. In a written document, for example, that might be somebody's birthday or a date that's important to you. Something that's there because you've put it in there purely to trip people up if they right click, copy paste and take your content. There's no reason for your birthday date to be in there other than as a trap. And if somebody does right click, copy and paste and the date is in there, then it's good evidence of copying. That applies to documents that you might see online, manuals, for example, guides on how to use products or services, but also when it comes to software development, it's a common thing to see in the programming notes. So again, at a time when content is being uploaded more freely to online platforms, think about these little tricks that can help you to prove copying in the long term. Moving on, think also about the cybersecurity risk. It's been reported that there's been a 400% increase in cybercrime relating to the pandemic. And that increase comes at a time when remote workers are at an increased vulnerability. There's almost a perfect storm of the scenario, making cybercrime a much greater risk at the moment. If you imagine a worker working remotely at home compared to when that worker is working in their office environment, in the office environment, if they see something suspicious land in their inbox, they're probably going to stick their head up in the open plan environment, speak to their colleague and say, have you also received this? Or does this look normal? Or do you think this is actually from the finance director? When working remotely, they don't have the ability to interact with their colleagues in that way. And so there is an increased risk that they'll just act quickly on the communications that they receive, for example, phishing emails. Not only that, but because they're not being micromanaged, perhaps, they may also be less inclined to raise their hand and notify their employer if they, excuse me, if they feel that they've committed a breach. So making sure that teams understand what to look for from a cybersecurity point of view, that their training is refreshed, that culturally the organization encourages individuals to come forward if they've witnessed a breach is going to be really, really important. Going back to the sharing of tools points again, if you're a developer coming at it from that angle, then we're seeing an increased appetite for, again, sharing content online. Just being aware of the security risks of content that you take on board is really important. Again, think, for example, of open source. If an open source library has a weakness and that weakness is publicized, then that weakness is replicated every time that open source library is used in a piece of code. There may well be a temptation now when teams are working remotely to use that sort of code, not intentionally using code that's got vulnerabilities in it, but using code that comes from other libraries more readily than would have otherwise been the case as a workaround to people working remotely. Do, though, be aware of the risks. Think always about whether or not using that code, whether it has vulnerabilities or not, and you're probably not going to know until it's too late, using that code is suitable for what you're doing. For example, if you're building a financial application for a client, you're probably going to be more sensitive as to where you get your code from than if you're building something where security is less obvious. So, cybersecurity, we are seeing a big increase in cybercrime activity, and businesses need to be aware of that, update their training, make sure their cultures are right, but also building products that help to maintain security for customers. Think next about how you communicate. We've spoken a little bit earlier about some of the online platforms. Many of the online platforms that make content that enable you to communicate for free have terms and conditions which possibly are going to cause you issues. We spoke a little bit earlier about the intellectual property side of things, but also from a data protection and a cybersecurity and a confidentiality point of view. Many businesses will have entered into non-disclosure agreements which prohibit them disclosing information to third parties. However, online communications tools, including video conferencing tools, are third parties, and many of them have the ability to record communications, to send information through text chats, or to have the person that runs that platform, the proprietor of the platform, the business behind it, to monitor or record those communications. Indeed, some of them to use those communications for their own business purposes. Check then that by using these platforms and communicating information to these third parties, even though that's not your main aim of using the communications platforms, that you're not going to be putting yourself in breach of any non-disclosure agreements or confidentiality obligations. Also, if you're developing technology and you're looking at your options for protecting the intellectual property in that technology, make sure that by using these platforms, you're not shooting yourself in the foot by giving the idea away in a non-confidential setting. Think, for example, about patents, where in order to obtain a patent, you need to have not disclosed the idea other than under a duty of confidence. Think also about the rights of any data subjects. If you're a business that has told your data subjects that you don't share data with third parties, and you then use online communications tools where you discuss that data, you are sharing the data with a third party, i.e. the communication platform, and your communication to your clients will probably need to change. Think also about whether or not those communications platforms are going to be based outside the European Economic Area. If they are, and the data is going to be stored outside the European Economic Area, or at the very least, if the platform doesn't guarantee that data will be stored in the European Economic Area, you'll need to think again about whether or not your communications to your data subjects needs to change. Again, if you're a business that has said you're not going to transfer data out of the EEA and you use one of these platforms, you probably need to refresh your communications or risk being in breach of your obligations. So tip 5, communicate, do it securely. At a practical level, think also about whether or not you need to communicate, excuse me, all of the information. For example, is it possible to have a communication with a colleague about a client without mentioning the client's name, without passing over the confidential information? So regardless of what's in the terms and conditions, regardless of the security, think about ways in which you can minimize the data that's being shared. Okay. Still looking at remote working and privacy, another trend we're seeing at the moment is businesses ignoring a lot of the hard work they've done towards their GDPR compliance as they rush to ensure that they can have business as much as usual as possible by having people working from home. Lots of businesses have spent a lot of time making sure that they are compliant with GDPR and other privacy obligations, but have forgotten that those still apply when working remotely. See, for example, the earlier points made about data sharing platforms and communications issues. Your privacy obligations still apply even when businesses are working from home. Indeed, the ICO, the governing body in the UK for GDPR, has envisaged for some time that organisations will want people to work from home and has expected organisations to have in place plans to make sure that that can happen securely. It's not going to be an excuse to say that the pandemic has changed the way in which organizations work. Rather, you should see this as a significant stress test of the systems you have in place to enable or to ensure, your GDPR compliance. Businesses should, at the very least, be conducting privacy impact assessments before they allow remote working. Those privacy impact assessments need to assess the tools that the employees are going to be using, the ways they're going to be operating, and the associated security. The privacy impact assessment is a tool which helps you go through the issues of any decision that you're going to make which has an impact on privacy, and to demonstrate how you get to a reasonable decision about whether or not to use that tool or to take that action. Think of it as a bit of like the way in which you show your workings in a maths exam. It shows the regulators, if you ever need to, that you've gone through the thought process to come up with a reasonable decision. If you've gone through the thought process and the decision you've made is reasonable, then great. If you've gone through the thought process and looking at all of the issues, your decision to use a particular technology or a tool or to remote work in the way you are is not a reasonable decision, then a privacy impact assessment won't help you. But going through the process of completing a privacy impact assessment should help you to ensure that you stay the right side of the law when it comes to privacy. Moving on, and this is linked to the same issue, remember that there's an old adage where online services are offered for free, you're often the commodity. The price you're paying for free online services is often your data. So think again about how those platforms are going to use your data, whether you've communicated that to the data subject, whether the use of the data in that way in any way scuppers your commercial plans. This is a key risk when using any free services. They generally look to make money one way or another, and if they're not charging you, it's looking at the data. Think also again about how this impacts on the data subject. Imagine, for example, that you're running a simple e-commerce platform and you have the ability on that e-commerce platform to sign up for newsletters. Somebody that signs up for that newsletter, you can be pretty sure that they want to receive the newsletter. They're consenting to you processing the data so that you can send them the newsletter. But that's different from you then taking their email address, passing it to a third-party email marketing company, possibly based outside the EEA, so that they can send emails on your behalf and do goodness knows what with the data. If you're going to use those sorts of systems, you need to be checking with the email marketing company how they use the data and relaying all of that back right down the chain to the end user who's asking for the newsletter. That's a fairly straightforward example, but the principle will apply no matter what the service is. Check if you're happy to pay the price, even for free services. Okay, moving on. We're seeing also an increase in reputational issues. Certain businesses are struggling to deal with the pandemic and working from home. Others are having to cancel contracts with clients and so on. And this is, as you might expect, leading to some reputational issues. For example, disgruntled customers. The tip here is fairly straightforward. Make sure that you have a plan for this. Make sure that your trademark registrations are up to date so that you can deal with any platforms where dubious content about the brand might be posted. Make sure that you have a PR plan in place so that you can deal with these issues also. As consumers have less and less real-world outlets for any disgruntlement they may be feeling, you may well see an increase in negative activity on social media and other online platforms. This next tip really relates to businesses that deal with consumers, so B2C relationships. And it's a reminder that the online environment is very different to the offline environment. The laws that apply are different. And the laws that apply in online transactions, online environments where you're dealing with consumers are really set up to protect consumers much more than they are protected in the real world. That's partly because the law recognises that consumers are more likely to make purchases quickly online. It's probably less painful to buy a product online than it is to hand over cold, hard cash in a store. And as a result, consumers might regret their purchase later. Similarly, the customer isn't able to see the product before they buy it, and they might get something that they weren't quite expecting. In order to protect consumers, there are a number of provisions in place, and this includes all sorts of things about the information that you have to provide to the customer so that they know who they're dealing with, having clear returns policies, delivery policies, not hiding charges and things like this. But one of the biggest ones that we're seeing businesses being unaware of at the moment is about consumers' rights to return. Now, there are some exceptions to this, but generally speaking, consumers have really powerful rights to return goods and to cancel contracts for services for any reason, even if, for example, the goods aren't faulty, just because they've changed their minds. The way in which businesses control this is by setting out a clear expectation between them and their customers in their contracts. Businesses that do this right and comply with the Consumer Rights Act can reduce the period in which goods can be returned to 2 weeks. Businesses that don't comply with the relevant legislation can have that returns period extended up to 54 weeks. That's a massive time period, 54 weeks. And it can end up with businesses creating a cash flow impact, or cash flow problem, I should say. If you imagine a consumer returning products within 54 weeks and requesting a refund, the business has got to have the cash available to make that refund. The painful thing here is that we're seeing businesses jumping into online solutions, selling goods and services to consumers to deal with an immediate cash flow problem in light of the lockdown, but in doing so, creating an even longer term cash flow problem for themselves in the longer term. Again, this issue can be easily avoided with a little bit of understanding and making sure that the terms and conditions on the website are compliant. Moving on, and at the risk of sounding like a lawyer, as your opportunity increases, so does your potential risk. We've spoken about the reputational risks of products not matching a customer's expectations or the negative fallout if a business has to cancel contracts, but think also about branding from an audience point of view. If you're used to trading in the UK or you're used to trading within a particular locale within the UK under a certain brand, then that brand might have served you well for some time. But when you switch to an online provision of goods and or services, you're increasing your potential audience. The brand that worked for you in the particular locale in which you've been trading may not work for you on a larger scale. For example, somebody else might have a registered mark that's the same or similar, and you may find yourself committing trademark infringement. We've also all heard stories of businesses who have used a brand in one territory which works fine, but which translated into local languages in other territories that they're moving to, it doesn't work at all and perhaps is even offensive. So again, checking the trademark position, doing a quick search before you sell to other territories, before you expand your remit geographically within the UK to make sure that you're not treading on anybody's toes from an infringement point of view, and that your own registrations are up to date so that you can protect your brand going forward and ensure that you can control the reputation that you develop is really, really important. Think also about how, when you're trading online, you increase your audience geographically, and you could easily find yourself having to comply with legislation in other territories. So, for example, a business which enables people to download software in the UK may also make that software available for download in other territories. And if they do, they could easily find themselves caught by the legislation in those territories. Simple ways that might indicate that a business is likely to be caught by the legislation of other territories would include, for example, delivery policies which specifically deal with those countries, displaying local currencies, and so on. So once again, not to say don't do it, do take advantage of the opportunities, but do so with your eyes open to the potential risks. So to wrap up, even though times have changed, the obligations on the businesses have not. This situation will test your legal position. It's a time when your terms and conditions stop being a document that sits in the drawer and gathering dust and really should be coming into their own. It's a time when your GDPR compliance will also be tested, where there are plenty of new opportunities, but those opportunities need to be taken advantage of in compliance with the legislation. Careful planning in the short term will ensure success in the long term, rather than quick actions now taken to survive, causing long-term negative consequences. For more information, please do get in touch with the email or Twitter. Look me up on LinkedIn. Happy to take any questions via the LinkedIn group as well. And that's it from me. Thank you.
Great, thank you so much, Ben. That was a brilliant session. If anyone watching has any questions, please give us an email at info@greymatter.com, or you can give us a call on 01364 655 100. As Ben said, there is also a Grey Matter ISV partner community group. We will be answering any questions that you have in there, so please request to join and we will admit you. Thank you very much.